Hello, everyone. Good afternoon. I hope everyone is doing great today. It's already midweek and we're looking towards the weekend now. All right, so I'm going to introduce myself to people who may be joining us for the first time today. My name is Ifeoma Odunlami. I'm an immigration attorney from the Odunlami Law Firm in Cedar Knolls, New Jersey. My law firm serves clients in all 50 states. Our mission and our vision, our purpose is to help our fellow immigrants gain legal status so that they can live here in the United States without fear of deportation, without fear of family separation, and they can go ahead and contribute to the American society, which is some of the purpose that we come here. We want to be able to live a free life, freedom. We want to be able to contribute meaningfully in a society that appreciates what we have to offer. So if you join me, please, say hello. Let me know where you're joining from. And if this is your first time joining me, then welcome. So, so typically what I do is I have a topic that I want to talk about because it's something that I feel that you must know because knowledge is power. The empowered immigrant is the immigrant that has information, that has knowledge, because in the immigrant community, there's always a lot of wrong information out there, and people act on it because you come into the United States, you're looking at the person who you respect and admire to guide you throughout your immigration journey. And sometimes they don't have the right information, or sometimes they have done things wrong themselves because somebody else gave them wrong information. So thank you, Alorzi and Baracom Services from Kenya. Well, thank you for joining me. So I'm on Instagram, I'm on Facebook, I'm on YouTube, and I'm on TikTok. TikTok is the new community I joined, and you guys are, well, thank you for joining me. Okay. So I give a little information, and then I take a couple of questions. And these questions, like I warn you, sometimes the answers would depend on your situation, and I don't have the luxury of being able to get all your information from a single line question. So it might be best for you to call and get a proper case evaluation of your case, a strategy session, so that we can figure out what is best for you. And so with that caveat, I'm not your immigration attorney. I don't know your information, so I'm only just answering general questions. So I want to talk about a success story that I had, and I want to talk about it because I want you also to have that success that my client got. So this client came to us, I think it was about 2021. Oh, wow, this is now 2024. And she already had a conditional green card, which meant she had a 2-year green card. And that 2-year green card, she got it because she was married to a US citizen for less than 2 years, right? At the time the green card was approved. And now her children, right? She had minor children at the time. They also got conditional green cards. And they got conditional green cards because the relationship, the marital relationship, was formed before they turned 18. So their stepfather also filed for them, and they got 2-year green cards. But the viability of their conditional green cards depended on their mother's conditional green card being subsequently changed to a 10-year green card. And all of you know that if you have a 2-year green card, it means that you have to file to remove the conditions on the green card. So it was important that her conditions were removed to get her the 10-year green card. And if that happened, their conditions too would be removed, and they would also get the 10-year green card. So now the marriage was not viable anymore. There was abuse in the relationship. And I remember this case very well because she didn't have a ton of evidence. She didn't even speak English, and we had to use an interpreter to get a lot of stuff done. And she didn't have a lot of information. And but we went ahead with filing a waiver. So let me back up a bit for those that don't know what I'm talking about. When you have a conditional green card, it's a 2-year green card. You have to remove the conditions so that you can get a 10-year green card. And when you get the 10-year green card, you then can go ahead to become a U.S. citizen, right? You can apply for U.S. citizen status. So when she came to us and she told us what happened in the relationship, it was a lot of emotional abuse. There was no physical abuse. So when someone tells you that you can only get your green card if you've suffered physical abuse, please do not believe them. There was no physical abuse. It was just emotional abuse. She was badly treated by her husband, and so we filed a waiver based on extreme cruelty. Now, there are 3 other waivers that you can file if you're trying to remove conditions on your green card. The first one is, divorce. If you're divorced from your spouse, the marriage is no longer valid, you can file on a divorce waiver. You can also file if the person passed away, unfortunately, definitely you can file with death as a waiver. You can also file if you can show that you suffered extreme hardship during the conditional period that would mean that you shouldn't, you need to stay in this country. That's number 3. And number 4 is extreme cruelty, physical abuse, similar to VAWA. Now, the difference is with VAWA is Violence Against Women's Act. So even though it's the same burden of proof in terms of what you're trying to show, right? With I-751 waiver, you already have a green card. You already have a temporary green card. With VAWA, you're trying to get a green card, okay? So we filed an I-751 based on extreme cruelty. And we wrote a really powerful declaration. And like I said, she didn't speak any English at all. But we were still able to get the story of what she went through, how badly she was treated by her husband, and we submitted it. Now, at this point, she had already passed the stage to, she was already qualified to get to apply for citizenship, but the USCIS had not made a decision on her I-751. So that if USCIS does not make a decision on your I-751 and you have the required amount of time to file for your citizenship, you can go ahead and do that. And that's what we did for her. So even though we didn't get the response to the I-751 yet, we went ahead and we filed for naturalization for her and for her 2 kids who were kind of semi-adults now, We filed for them. And typically we do this because we're trying to get USCIS to respond to the I-751, because they're not going to naturalize you without approving the I-751. All right. So we did that, and we went. They filed naturalization. They called them for an interview. We went with them with an interview, and we met all the evidentiary burden required, and our client, the mother, was approved to become a U.S. citizen. Right. Now, her children also got their interview dates, but at the point that they got their interview dates, their mother's naturalization application had not been approved, so they had to wait. So finally, our client became a U.S. citizen. Her children also were called in for swearing in, and they became U.S. citizens. So now we have 3 U.S. citizens, and the reason I want to bring this to you is, I want to talk about this is because a lot of people feel that when they get the 2-year green card, that, they're pretty good, nothing else to do. I want to tell you this, I-751s are tough, because USCIS, this is one of the last chances they have of making sure that they got it right when they give you a temporary green card. So when you get your temporary green card, it's not the time to relax. If you're still married to your spouse and you're going to remove the conditions jointly, you want to continue preserving evidence of a bona fide marriage, right? You want to show that the marriage is, you're still a marital union. If for some reason that marriage has not worked out, you want to be able to prove certain things. You want to still prove that it was a real marriage at the time it occurred, right? You want to prove that if you're using the physical abuse or extreme cruelty, you want to show that you have suffered physical abuse or some kind of emotional, psychological abuse, whatever it is, right? You also want to show that you are, if you're removing your waiver based on divorce or based on death, you still have to show that it was a bona fide marriage before the divorce happened, before the person passed away. And actually, the only waiver that does not require you to prove a bona fide marriage is the waiver of extreme hardship. But the rest of them, you need to show that. So don't assume that because you got the 2-year green card that you're going to sail through. They're very thorough on those interviews, the I-751 interviews, because now you had a social security, you had the authority to work. There's really no reason for you to say you can't bring evidence of your life with your spouse in the United States. So if your I-751 is denied, you can be put in removal proceedings. And so if your I-751 is denied, you need to talk to a lawyer right away, because there's certain things that we can do, to reinstate you back to legal status while we're fighting the denial. Okay, so I want to talk about some reasons why people why their cases get denied, their I-751 removal conditions get denied. Well, number one, it could be a lack of evidence. Maybe they don't have the bona fides. They don't have proof that it was a bona fide marriage. Now, you guys know that one of the biggest immigration violations that immigration does not forgive is a sham marriage. If you marry somebody solely and only because you want them to help you get a green card, and it's a sham marriage, right? That is a big immigration violation. It's a permanent bar, actually. So having to prove that you're in a bona fide marriage is something that's really important. And I tell my clients, it's something that is your responsibility. Don't put it on your spouse and hope that they are doing what they're supposed to do. You want to make sure you're the one gathering this evidence. If you have pictures, make sure you're loading them on the cloud, because I cannot tell you how many clients come to me and say, well, that camera or that phone got stolen. There's no reason for you not to back up your pictures. There's no reason for you not to take pictures and load it somewhere and save it, okay? As long as you're not a US citizen, your immigration journey is not over, all right? And because even if you get your green card, you can still be deported, all right? So you want to continue being attentive to the requirements that you need to meet as a green card holder so that you can naturalize, and then your immigration journey is over, all right? So proof of bona fides, USCIS loves financial commingling. They love to see that people have their finances together. Now, if your finances are not together for any reason, you have to explain why, right? They like for you guys to live together. If you don't live together, you have to explain why. They want to see a slice of your life. Are you taking vacations together? Are you out in public together? Do people know you to be a couple? Do you have a joint bank account, which shows that there's activity between both of you and your spouse? Because USCIS will scrutinize those bank accounts. And some of the things that they see that make them suspect a sham marriage is where they see that somebody in Texas is using the account and somebody else in another state is using the account, but you guys present at the interview and claim that you live together. That's something that, those discrepancies, it's better to explain it than to lie, okay? You can say, whatever it is, maybe one of you is in school and, that's why you're in Texas most of the time. And the other, or maybe you have a job that requires you to be there most of the time and you travel back and forth. It's better to tell the truth and explain than to lie about it. So USCIS also likes to see how you present yourself to the public. Do people know you're a couple? Sometimes they'll do fraud investigations where they go to your neighbors, they go to your work, and they typically come really early in the morning when they come to your house because they want to see if both of you slept together, live together in the same place. They'll open the closet to see if that person has clothes there. They'll go to the bathroom to see their toothbrushes, more than one. They will look and they will check, these are what we call fraud investigations. So it's really hard to, to fool them. Okay. So you want to begin to put your bona fides together. And if for some reason your relationship is not working out because maybe there's abuse in the relationship, whether it's, emotional abuse, psychological abuse, financial abuse, whatever it is, talk to a lawyer, because it doesn't mean that you're not going to get your green card. You just have to use a waiver. Okay. So if your denial letter tells you that your evidence, you didn't have proof of bona fides, then you know that that's what you should have gotten, and that's what you need to get. Now, sometimes your I-751 will be denied because you filed it too early. You're supposed to file within 90 days of the expiration of the green card, no earlier, okay? And typically, try not to file it late. If you file late for some reason, put an explanation why it's late, okay? Now, criminal activity, if you have committed a crime, especially during the period that you had your green card, that can get you denied really fast. And of course, if it's an aggravated felony, I don't even need to speak to that. But if you've committed a crime, you need to talk to an immigration lawyer. If you're in a criminal court and you have to take a plea, you want to talk to an immigration lawyer before you take any pleas, because some pleas have immigration consequences, okay? And so if you get a denial, that's the time that you need to talk to an experienced lawyer to make sure that they can put you back on track, okay? Now, remember, this is what I want to tell you guys. If you get a conditional green card, a 2-year green card, right? Or rather, if you get a 10-year green card when you're supposed to get a 2-year green card because USCIS made a mistake. So you're married to a US citizen, you get your green card approved before your marriage is 2 years. You're supposed to get a 2-year green card, not a 10-year green card. If they make a mistake and give you a 10-year green card, that's not luck. You need to let USCIS know that they made a mistake. You have to send it back. You need to make sure you're getting the right thing, because when you go for naturalization, you're not going to be able to naturalize because you didn't remove your conditions, even though it was USCIS's fault. But you should know that you're not supposed to be getting a 10-year green card when your marriage wasn't over 2 years at the time of the approval. So let's see. Okay, I'm going to take some questions. Let me start with hi, Akim. Hello, Natalie. How are you? So Hiram Wamweya says, have little evidence for I-751 solo spouse sabotaging, creating it. Do I stand a chance? Of course you stand a chance. I just talked about this case where, honestly, my client didn't have any physical evidence of the abuse. I didn't have a lot of evidence for the bona fides, but she was able to show why, because the reason she didn't have evidence of bona fides was part of the abuse. Her spouse was sabotaging her ability to get a green card by purposefully refusing to do certain things, okay? So yes, Hiram, you stand a chance. If you're worried about this, call our office. Let's screen you and see how we can help you. 973-993-1900. And Natalie says, I have a question. Can my nephew who has a green card and has a charge of furnishing tobacco travel internationally? He's 19 years old in the state of Georgia. So he has a criminal charge. So he needs to talk to a lawyer. So I'm not gonna tell you what his chances are of keeping his green card, because we need to actually review the criminal documents and see what he was charged with and see what level of what kind of crime it is. Whether it's a misdemeanor, whether it's a felony, and we also need to know how soon after he got his green card he was charged with this. So there's a lot of important information we need to know. And but every time there's a criminal charge, Natalie, it's not something to play around with, okay? So you want your nephew getting proper advice. Ivan says, do you process religious worker petitions on top of your specialized work? Ivan, yes, we do. We do R1s. But I want to tell you guys this because I get a lot of calls for R1s. I don't want you to waste your money. If you are here in the United States and you're out of status, an R1 is not going to work for you. An employment visa will not work for you either. So if you're here and you're out of status, somebody filing a religious visa is not going to be helpful to you. Okay. All right. Tamara says, how about EB2 NIW? Yes, we have attorneys in my office that work on that. So if you need assistance with that, give us a call, 973-993-1900. Hiram says, thank you. You're welcome. Natalie, pleasure. Okay. So let's go on Instagram and see if we can answer a few questions. Hey, Instagram people. Let's see. I'm going, looking for questions. Some of the questions are not questions, so I'm not really sure. Somebody says I'm underage. I'm not sure what that means. So Juicy says, my name is Kennedy. I came to America on a J1 and left after the program and would like to come back. Kindly let me know the most appropriate route to come back, either B1 or B2. I mean, the way to get a B1 or B2, I mean, there are many ways to come back to the United States as long as you didn't overstay or become inadmissible for one reason or the other. But a B1, B2, you just need to go and apply, and you have to show that you have ties in your country and you intend to return back. Same thing with an F1, same thing with a J1 that you came with before. So I don't know what your qualifications are, but you can also have someone file H-1B for you or file a perm petition for you. There are lots and lots of things that you can do, but without knowing more, having more information about you and your particular matter, I can't tell you more, okay? All right, let's see. All right, I'm still on Instagram. And Salawu, thank you. So I'm gonna go to TikTok. TikTok is hard to read because the prints are so small. But I'm gonna try for you guys, okay? All right. I have a lot of questions on TikTok, so I'm gonna scroll all the way to the top so I can take it as it comes. Thank you. I think Mariama Jala, thank you very much. Thank you for joining me. All right, looking for a question. Torcio says his ESTA was canceled by the CBP at the airport. Well, you can reapply, but you're going to have to look for, you're going to reapply for a visa because if your ESTA was canceled, there's a reason it was canceled. So you're going to have to go ahead and reapply to get a visa, okay? And I wish you luck with that, okay? All right. Christelle says, my mom's last name is Odunlami. Oh, wow. Well, Odunlami is my married name, okay? That's my husband's name, but maybe we're related through marriage. All right. So Malika says, hello, is a divorce final or legal if you get a foreign divorce, but didn't serve it to your ex? So Malika, you're asking me a question that I really cannot answer because the rules or the law regarding divorce really depends on the country. What are the laws that are attendant to a divorce process in that country? So typically, USCIS will give what we call full faith and credit, which means they will recognize if your country recognizes the divorce, they typically will recognize it. So if your country doesn't require you to serve the person and they recognize it, USCIS will as well. So you might want to go to the travel.state.gov website and look for go under the document authentications, look for what USCIS recognizes in your own country, because like in Nigeria, USCIS will recognize customary marriage, and they do recognize divorces that are not formalized because Nigeria does. So that might be the way to do it, okay? But if you are concerned or have more questions, call my office. Let's do a strategy session with you and see what's going on with your case, okay? All right, so. All right, let's keep looking. I'm looking for questions. So somebody says, how long does it take for Form I-824? It really depends. We have some cases that it went pretty fast, but in some cases it takes up to a year. So it really depends. All right. So I would say anywhere from 6 months to a year, really. All right. So Tracy says, can you get a green card through business if you overstay your visa? No, you cannot adjust your status. Okay. But if somebody's willing to file for you and you've overstayed and you have a U.S. citizen parent, U.S. citizen or green card holder parent or spouse, you might qualify for a waiver that may allow you to travel and consular process and come back. Okay. All right. So I'm not going to answer questions on B1, B2 denials because it is what it is. B1, B2s are non-immigrant status. There's nothing we can do, really legally, because it depends on why you were denied. All right. So, and you can appeal a B1, B2 denial. So, yeah. Karine Miller says, what is your consultation fee and what state are you in? So Karine Miller, our consultation fee is $200. We are in New Jersey, but we represent clients in all 50 states because immigration is federal law, and so we can do that. Tamara, you're welcome. And so let me see if I can get a couple more questions. Amitio says, I received a letter stating that they extend my green card for 2 years instead of 10. So it sounds to me like what you got was a conditional green card, which means that your marriage, when you got the green card, your marriage was less than 2 years. So that's what that is. If it's anything different, then reach out to USCIS, okay? So Andrea McLean says, I was to go to an interview February 2023, but my husband was sick. I speak with USCIS, me, a lawyer from that. I don't have anything. So, well, Andrea, first of all, did you contact them and submit proof that your husband was sick? Because you want to make sure your case hasn't been denied because you didn't show up. It might be a good thing to reach out to them on their customer service line and call them. Or if you had a lawyer, ask the lawyer to do a FOIA and make a request to see what's going on with your case, okay? All right, so Ngizi says, what do you do if you were put in removal proceedings? So if you're put in removal proceedings, that's pretty serious. It means that they're trying to deport you. But the thing is, in removal proceedings, sometimes it's not a thing to be scared about. There are avenues to get your green card, even if you're in removal proceedings. So it depends on why you were put in removal proceedings. It depends on your situation, so that we can check whether you can get a green card even if you're in removal proceedings. We have many the immigration judge has powers to give you a green card based on certain case types that USCIS does not. So if you're put in removal proceedings, this is serious. Call a lawyer, call us. We work with a lot of people in removal proceedings. And sometimes we can even do something called a prosecutorial discretion and get you out of removal proceedings. The number to call is 973-993-1900. Somebody says, do they still require that if you got your green card through VAWA? No, if you get your green card through VAWA, it's not a conditional green card. If you get your green card through VAWA, it's a 10-year green card. Okay, that's a really great question. All right. It's a 10-year green card. And the good thing about VAWA is if you get your green card through VAWA, you don't have to wait 5 years to qualify to begin the naturalization process. After 3 years, 90 days within the third anniversary of getting your green card, you can apply for naturalization. Isn't that wonderful? Yeah. All right. Okay. All right. I don't think I have any more questions, and I'm gonna skedaddle out of here. So somebody says, Prudence says her asylum was granted, when can she apply for a green card? Within a year of your asylum being granted. Congratulations, Prudence. All right. I think I have one. Somebody says, can I be spouse? I don't understand this question, so I'm going to skip it. Another person asked this question, which I've answered already. Can you get a green card through your business if you overstay your visa for over 7 years? No, you cannot. Not by adjustment of status, anyway. If you get a waiver, you may be able to. If you qualify for a waiver, you may be able to consular process back in. Okay, Ogochi says, do VAWA cases stay up to 3 years? If VAWA case stays 3 years with no RFE, what is the issue? Sometimes there's no issue. USS is backlogged, Sometimes there's no issue, so I wouldn't worry about that. All right, guys, it was a pleasure talking to you guys. So I'm going to head out because I have a 4 o'clock consultation, which I need to prepare for. But I will be back next Tuesday, and I look forward to chatting with all of you then, okay? Come in with your questions, all right? Take care. Bye-bye.